Hey, in this video, we talk about understanding agreement of purchase and sale, also known as the APS, but in a much simplified way. So if you're buying or selling your next home and you wanna refer to this video so you won't feel lost or confused, you might wanna pay attention to this information. And feel free to always refer to it, pause, stop, do what you gotta do. However, stick around to the end so that you could get complete value and be a much informed buyer or seller. We're gonna get into it. Hey, if this is your first time on this channel and you wanna know everything about eating, sleeping, playing, good, bad, about living in Simcoe County and York region, which is all located in the province of Ontario, you wanna subscribe below and tap the bell notification. You could be the first to know about the current markets in the Simcoe County and York region. My name is Solomon. I'm a Mensa with Amore Realty. We get calls from people like you who are ready to make a move to Simcoe County or York region and who absolutely love it. So if you're making a move in 9 days or 90 days, shoot us a call, text, or email. We'll help you love your journey home. The offer date. The date of offer is the date when the offer is first drafted and the date does not change. So for example, if a salesperson drafts up an offer on April 23rd, 2023, and the buyer signs it on April 24th, 2023, the offer date will be April 23rd, 2023. Names of buyer and the seller. So that usually is the individuals. It must have full legal names of the buyers and sellers. So names on title, that would be the names registered on the title. So that would want to be pretty much the same on the agreement, so that it could be the same on title as well. Identification, each buyer must be identified on a separate form and must comply with FinTrek. Corporations, if the buyer or seller is a corporation, they must use the full legal name of the corporation as it's indicated on the Articles of Incorporation. Real property. Real property, we're first going to begin with address. It should be the full municipal address, including the name of the town and the region. In the frontage section, you're going to insert the frontage and the depth of the lot. The words more or less are used to avoid minor discrepancies. Age description, complete legal description as given on the title deed. You would refer to any easements, mutual driveway, anything that's going to be given, we must provide it in the age description. Fronting. On this, you would want to ensure that if it's on the side of the road where the property lies, if the property is facing an opposite side, you just want to be descriptive as possible when it comes to fronting. Purchase price, also called the offer price. The amount is written in words and in figures, in numerical figures. Deposit. There is no minimum amount set for deposits. The deposit holder is typically the listing brokerage. Deposits held in trust accounts until completion or termination of the agreement. At this point, you'll see words like herewith, which means the deposit is given with the offer. Upon acceptance, the buyer agrees to give the deposit within 24 hours of signing the confirmation of acceptance. As otherwise described in this agreement, if some other arrangement is to be made with the deposit, a clause must be inserted in Schedule A. Now, let's talk about the pre-printed clauses. Irrevocability. So this is the time period by the buyer or seller that the other party must consider the offer. The offer cannot be withdrawn by the offered until the given date and end time. However, if the offer has been communicated to the other party and the party making the offer may withdraw the offer. The offer becomes null and void when the irrevocable time period expires. The other party may extend this date and time when making counter offer during negotiation. Completion date. This is the date when the title of the property is legally transferred to the buyer. Keep in mind it cannot be on a Saturday, Sunday, or a statutory holiday. If nothing else is agreed, the buyer will be provided a vacant possession of the property on completion. If the property is rented and the buyer agrees to assume the tenants, appropriate clauses must be inserted in the schedule. If the buyer does not want to assume tenants, the situation should be addressed according to the Residential Tenancy Act. Notices. The parties authorize their brokerages to send and receive notices on their behalf. Fax numbers, email addresses of the listing brokerage and the cooperating brokerages are provided for delivery of documents. Notices are deemed delivered when sent to electronically by fax or email. Usually this section is left blank if the buyer is a customer of the listing brokerage, if there's multiple representation, and if it's instructed by the parties. Section 4, chattels. A list of chattels that are to be included with the sale. The seller has the right to remove all chattels if not specifically included in the agreement. A good rule of thumb is, when in doubt, spell it out. You want to be as descriptive as possible as what's to be included in the chattel section. Section 5, fixtures excluded. A list of items fixed to the property that the seller does not want to give. The salesperson must be very careful about built-in items such as dishwashers. The seller cannot remove any fixtures if it is not specifically included in the agreement. Section 6, rental items. This has become an important issue in recent times. There are a number of items that are potentially not owned by the seller, but rather leased or rented. The seller would have to identify these to a buyer. An important issue these days is the hot water tank. These may be rented or more frequently now on contract for lease to own. So we must insert that in the APS so that we ensure that the buyer is aware. Section 7, HST. This section must not be left blank. Most residential resales are exempted from HST. Included in means that the seller is responsible for HST. In addition to means that the buyer is responsible if HST applies. Section 8, title search. So there are a number of searches that the lawyer may undertake when working on a real estate purchase. This paragraph sets out the times for those searches to be done. The searches may include the title search, existing mortgages, work orders, among others. Present use. The permitted use of the property, such as single-family residential, is inserted here. Zoning of the property must not be inserted in this space. If this space is left blank, then it implies that the seller represents the present use of the property and may be lawfully continued, and it may be insured against risk of fire. Future use. The buyer and seller agree that there is no warranty that the future intended use of the property by the buyer would be lawful. So example, I can't turn a house that I'm interested in into a disco club and put it on the seller. No, it doesn't work like that. If the buyer wants to use the property in a way other than the present lawful use, an appropriate clause should be inserted in the schedule. Title. The clause sets out that the buyer is entitled to good title subject to a number of items. These items include having title subject to minor utility easements for gas, water, hydro, and so on. The buyer will also have to accept the restrictive covenants provided that they are complied with. Closing arrangements. The seller's lawyer prepares the transfer deed of land for electronic registration. The buyer's lawyer completes the electronic registration of the title and other documents such as the charge of mortgage. Most transactions in Ontario are completed electronically. Section 12, documents and discharge. The seller is only required to produce documents that are under their possession or control. So for example, the survey, the seller must provide a survey if it is in their possession. Mortgage discharge, the buyer accepts personal undertaking of the seller's lawyer to discharge the mortgage using funds received from the sale. Section 13, inspection. The buyer acknowledges that they have inspected the property and observed any patent defects. If a home inspection clause is not included in the agreement, the buyer will not be permitted to inspect the property again. If the buyer wants to inspect the view of the property one or two more times before completion, an appropriate clause must be inserted in the schedule. Section 14, insurance. The seller is responsible to keep the property insured until completion date. Insurance coverage is not transferred on sale. If some major damage happens, and the buyer has two options, either they could terminate the agreement or take proceeds from the seller's insurance to complete the sale. Let's talk about Planning Act in Section 15. The agreement is invalid if the transfer does not comply with the Planning Act. In case of land which is subject to severance, the seller can accept an offer. However, the agreement will be completed only after receiving consent for severance before completion. Section 16, document preparation. This clause identifies the party which is responsible to pay the cost of document preparation. The seller pays for the transfer of the title. The buyer pays for the cost of mortgage documents and the applicable land transfer tax. Section 17, residency. Non-resident sellers must pay capital gains tax. I can't stress that enough. Non-resident sellers must pay capital gains tax. If the seller fails to pay, the buyer becomes responsible. So please do your due diligence if you are in a transaction with a seller that's a non-resident. The agreement provides the following options to the seller. Deliver a certificate from the Minister of Revenue after paying the necessary taxes, or credit the buyer for the amount of capital gains taxes, or provide a declaration that the seller is not a non-resident. Section 18, adjustments. This clause specifies that the certain costs will be apportioned at the time of closing. Typical adjustments include property tax, unmetered utilities, heating, rents for rental property, and many more. Adjustments are based on the number of days that the seller and buyer have owned the property. The buyer is responsible for the cost from the actual day of closing. Section 19, property assessment. The property may be evaluated and reassessed on an annual basis. The buyer and seller agree not to hold the real estate people responsible when change takes place. Section 20, time limits. This clause specifies that time limits given in this agreement must be strictly adhered to. If there are any changes, there must be agreed to by both parties in writing. Section 21, tender. Each side must be able to demonstrate that they are ready, willing, and able to complete the transaction. For the buyers, generally, they must be able to produce the money to close. And for the sellers, generally, they must produce the deed and pretty much the keys to the home. Section 22, Family Law Act. The seller warrants that spousal consent is not required under the provisions of the Family Law Act. However, if the property was a matrimonial home, the non-owner spouse must give written consent by signing the spousal consent section. Section 23. I'm gonna try very hard to pronounce this, but the acronym version is called UFFI. Simply means urea formaldehyde foam insulation, which was used to build homes in the 1970s. Sellers warranting that they did not install any urea formaldehyde foam insulation, and to the best of their knowledge that there is none in the building. Now let's go to section 24. Legal, accountant, and environmental advice. Buyers and sellers, I want you to understand your real estate agent is not someone you go to for legal and accountant and environmental advice. So let's break it down here. It simply means that the parties agree that information provided by the brokerages is not to be considered as any expert advice on legal, accountant, and environmental matters. If required, the seller and buyer should be advised to seek third-party professional advice. Section 25, Consumer Reports. This disclosure is required under the Consumer Reporting Act. The buyer is informed that a personal or credit check may be obtained and referred to. Section 26, Agreement in Writing. This clause states that if conflict is to arise between the pre-printed clauses and the inserted clauses takes priority. Further, there are no agreements between the buyer and seller other than those contained in this agreement. Section 27, Electronic Signatures. This provision ensures compliance with the Electronics Commerce Act in that it is necessary that the parties to an agreement consent to the use of electronic signatures. Section 28, Time and Date. This clause specifies that dates and timings given in the agreement refer to the place where the property is located. Section 29, Successors. In an unlikely event, and we hope this is a very unlikely event, that the seller or buyer dies before completion, agreement states that their heirs, executors, administrators, successors, and assignees are bound by the terms of the agreement. So salespersons should advise their clients to seek legal advice in this matter, but again, we hope that that does not happen. We're almost done here, and I remember I said that you're gonna get value if you stay through the end of this video, and we're almost there. So let's talk about signatures for buyers and sellers. All parties to the agreement must sign and insert a date. Initials of the buyers and sellers are required at the bottom of every page where there's no signature present. Initials indicate that the parties agree to the contents of that page being initialized. Witnesses. If you do use witness in this agreement, any competent person can sign as a witness. If a dispute arises, the witness may be called to testify. So we have to ensure that they're a competent person. In the unlikely event it goes into legal matters, we want to ensure that they're competent. Typically, the salesperson for each party inserts their signatures as witnesses. The witnesses must be physically present, must have attained age of maturity, must be a third party, and must not be a party in the contract. In case of multiple representation, representation, the same salesperson or salesperson from same brokerages sign as witnesses. Spousal consent. Spousal consent is required if the property is a matrimonial home and one of the spouses is not on the title. The signatures of the non-owner spouse must be also witnessed. Confirmation of acceptance. The last party to accept all changes signs and dates this section. This section must be completed before the irrevocable date and time given on page 1. Information on brokerages. This section provides information on the listing brokerage and the cooperating brokerage. In case of multiple representation or when the listing brokerage is providing customer service to the buyer, the space for the cooperating brokerage is left blank. Acknowledgement. Each party acknowledges that they have read and understood and received signed copies of the accepted agreement. This section is completed after the confirmation of acceptance has been signed. This section also authorizes the brokerages to forward copies of the accepted agreements to their respective lawyers. The lawyer's information may be completed right away or completed later. Commission trust agreement. When two different brokerages are involved in the transaction, the salesperson of each brokerage signs on behalf of their brokerages. The commission trust account protects the commission of the cooperating brokerage in case of misuse of funds or bankruptcy of the listing brokerage. This section is left blank if there is multiple representation situation or when the listing brokerage is providing customer service to the buyer. Schedule A. The names of the buyers and sellers is usually located here. The property addresses must be also inserted here for reference. The date on this page, any additional clauses are required, and attach any other documents to this section as well. Hopefully you found this helpful. Again, leave us a comment. Let us know if you understood an APS in the past while you're buying or selling in a transaction. Let me know how you felt about it. Was it complicated? Was the Shakespeare literature overwhelming? Let's have a dialogue. When other people, are looking up this information, they could see your comments and gather their own information and allow it to apply value to them so they can make an informed assessment when looking at an APS. So we mentioned before, my name is Solomon. Whether you're moving in 9 days or 90 days, feel free, give us a call, shoot us a text or an email so we could schedule a Zoom call. All the description are found below. Until next time, we hope we can help you love your journey home.